This has become the most important charge, really, felony charge that they've used in the January 6th cases. It's called corruptly obstructing an official proceeding. And right now we've got more than 760 people charged in federal court for crimes arising out of January 6th, and more than 280 of them are charged with this offense.
I'm Benjamin Wittes, and this is the Lawfare podcast, March 15th, 2022. It's been an eventful week in the Department of Criminal Cases arising out of January 6th. We had the first jury verdict convicting an alleged 1/6 perpetrator. We had an Oath Keeper guilty plea for seditious conspiracy. We had the indictment of the head of the Proud Boys. We had a judge, for the first time, rejecting the lead charge the government has used in a whole lot of criminal cases arising out of the Capitol insurrection. We thought it was a good time to catch up with Roger Parloff, who has been covering 1/6 criminal matters for Lawfare. He joined me and a construction crew in the virtual jungle studio to discuss the news of the last couple weeks. It's a wide-ranging conversation. We cover a lot of ground, focusing particularly on Judge Carl Nichols' controversial ruling about the availability of an obstruction prosecution to the government. It's the Lawfare podcast, March 15th, a 1/6 check-in with Roger Parloff. So, Roger, let's start with the conviction last week of Mr. Reffitt. This is the first jury trial in a January 6th case. You wrote a considerable curtain raiser on it. The curtain wasn't up for very long. Tell us about what happened.
Yes, the evidence came in as expected, and he was convicted in less than 4 hours. Some have said close to 3 hours. And there was just a lot of evidence, a lot of digital evidence. There were video clips of I guess I don't have to say alleged crime anymore, from 10 different cameras. There were excerpts of audio, basically confessions that his son had recorded covertly on his own cell phone. And then Guy Reffitt, after he got back, the confessions were after the event, of course. And then after the defendant got back from Washington, he also did a Zoom call with several militia members, fellow militia members. He was a member of the Texas 3%ers, and recounted the crimes he had committed and some additional crimes he wanted to commit. So I don't know if I've ever seen as much. And then there were, SMS threads, texts, Telegram threads with militia guys, again, recapping the highlights of his crimes and future ones he wanted to commit, also planning the crimes in advance. So I don't know if I've ever seen so much digital evidence. And it's a little extreme, but it's not that unusual in these cases. At least 77% of these cases, according to the George Washington University Project on Extremism, the arrests were made in part based on social media because, most of these people were proud of what they were doing. So they were there because they felt they had been called there by their president. And so they were videotaping themselves. They were posting online videos. They were boasting about it beforehand and afterhand, just like him. So this isn't going to be completely unusual, although I do think the government was probably happy that with the draw here that this happened to be the first guy to go because, and he was one of the very few that actually brought a loaded firearm to the Capitol. So that made his case unusual.
So why did he go to trial here? Usually, a competent defense lawyer faced with a client who is in fact guilty of a number of felonies, whose felonies are well documented on all sorts of social media, electronic material, etc. To all you out there who are contemplating conspiracies, don't use Zoom for your conspiracies. It's not a good platform for that. He left a huge trail, and his son was willing to testify against him. Why, under those circumstances, does a competent defense lawyer let this go to trial?
Well, as you know, it isn't the defense lawyer's final call. It's really the defendant's call, and some of these defendants are not terribly realistic. And he had actually been interviewed in the press once on ABC. He had said, "This is, through a call from jail to his one of his daughters." And he said, "This is going to be a simple case. It won't be hard to show that I didn't do anything." And I know his wife was supportive. His wife was very surprised and angry about the outcome. So they live in a bit of a bubble, and they're not being offered anything. When the evidence is this strong, the government isn't saying, "Do you want to get a B misdemeanor?" They're saying, I'm not there, but I know from the people that did plead to these sorts of crimes are getting serious time, between 41 and 63 months so far. So that's, if you feel like, are you really willing to plead guilty when you're, and with him, he's waited a long time. I don't know if he would get such a good deal. So, I guess there's just, you feel that you've got nothing to lose.
So what is he likely to get? I mean, if you actually string together the maximum sentences on all of these offenses, he could get, dozens of years, but that's actually not the way the guidelines work. So what does a refit sentencing look like realistically?
Yeah, the sentencing memos haven't been filed, and it's very hard to do the guideline computations. I just know that, given that a lot of people with the similar crimes got, say, 44-month sentences with a guilty plea, which usually gets you sort of an offense severity reduction of 3 levels for purposes of the sentencing guidelines. You know, I would think he's going to get 5 years or more, but that's just sort of a wild guess.
Before we move on, are there other trials that are actually coming to trial date in the near future?
Yeah, there's a number of them in April. Unfortunately, there's one in March that might not go as well. There's one next Monday, the 21st. It's a bench trial, meaning no jury, and it's a misdemeanor. And it's actually one of the lightest misdemeanors. It's a guy, I think his name is Cooey, but he didn't even go in the building. He was outside on the steps with a bullhorn, which is still within restricted zone. And so it's a Class A misdemeanor. And most of those people pleaded guilty, but he refused to. And there really aren't a lot. In fact, I only know of 2 misdemeanor cases that actually involve, these are nonviolent cases where the person did not go in the Capitol. There are a lot of cases where people fought with the police and never got inside the Capitol, and those are very serious cases. All those guys out on the West Terrace near that archway you've seen, the really brutal fighting. But this guy was not involved in fighting. So he's actually become sort of a cause celeb in some communities. The sort of January 6th denialist community. And in fairness, this is a light. He didn't do a lot. He promised to do a lot of offensive things, made a lot of offensive statements, including on TV, but those aren't crimes. And he's also going to go to trial before Trevor McFadden, Judge Trevor McFadden, who has been the lightest sentencer in these cases. I would say he's maybe the most hostile to the January 6 cases. That's a little strong. Maybe it's too strong. But he is the one judge who has sort of entertained the notion that the attorney general is treating these cases more harshly than he treated the cases emanating from the Black Lives Matter rioting or from the riots in Portland. In fact, he's actually said that he may give lighter sentences because of what he sees as a disparity. He is a Trump appointee, so he is. I don't know how that one's going to come out. That's going to be an interesting case.
So we also last week had a major new indictment at the high end of the offense scale, a new conspiracy indictment. Tell us about Enrique Tarrio and the Proud Boys indictment.
Yeah, Enrique Tarrio was the chairman of the Proud Boys at the time of the insurrection, and so he was finally arrested and added to an existing conspiracy indictment of 4 other Proud Boys, the top Proud Boy officers, if you will. And then one additional Proud Boy was moved over into that indictment, a guy named Dominic Pezzola, who was the guy that broke out the first window through which the first rioters jumped in on the Upper West Terrace. Enrique Tarrio, it's not a complete surprise. He had been quoted in some of the other Proud Boy conspiracy indictments, his social media entries, his Telegram chat instructions. So, and he was called Person One in some of the other Proud Boy indictments. But he wasn't present on January 6th. He came January 4th. He was arrested for burning a Black Lives Matter flag in December after a Stop the Steal rally. And he had on him at that time 2 large magazines. They were suitable for an AR-15 or an M4 rifle. And so he was arrested. And on January 5th, the judge released him but ordered him to leave D.C. And interestingly, before he left D.C., he did have a brief 30-minute meeting in a underground garage with Stuart Rhodes, who's the head of the Oath Keepers. That was the night before the January 6th, with a few other people. And that's mentioned in this indictment. And they allege that somebody brought up the Capitol in this short conversation. There isn't a lot known about that conversation, though. But what had been known beforehand was that he was involved in the planning, and it was very damning evidence. At least, he hasn't been proven of anything, but what he was doing was instructing them, we're not going to wear our colors this time. The Proud Boys have distinctive black and yellow colors they wear with a laurel symbol that's actually been sort of co-opted from Fred Perry, the designer. So he wanted instead to mix in with the crowd, and only they would know. And the implication was that they were going to incite the crowd, and the crowd wouldn't realize that these were Proud Boys. They would just think, oh, these are other, people like me that are fed up. And they played a rather, allegedly, but, from the indictment, they played a crucial role. I mean, they were among the first to topple barriers and to break through barriers and of course I mentioned Pizzola broke out the first window with a stolen riot shield, and about 6 Proud Boys were among the first to jump inside the building. Others broke out other doors. So the Proud Boys really played a crucial role, and so Tario is finally been arrested. He was charged with conspiracy, and I was a little surprised. He was also charged with aiding and abetting to do basically all of the crimes that the other guys are charged with, even though he wasn't in D.C., which some of which seemed a little aggressive. There was one new piece of evidence, one paragraph I thought was really intriguing, and I'll just read it if I can. It says that between December 30th and December 31st, so that's a week before the riot, Tario communicated multiple times with an individual whose identity is known to the grand jury. On December 30th, this individual sent Tario a 9-page document titled 1776 Returns. The document set forth a plan to occupy a few, quote, crucial buildings, unquote, in Washington, D.C. on January 6th, including House and Senate office buildings around the Capitol, with, quote, as many people as possible to show our politicians we the people are in charge, unquote. After sending the document, the individual stated, the revolution is important than anything. So I think meaning more important than anything. And Tario responded, that's why every waking moment consists of ... that's what every waking moment consists of ... I'm not playing games. But I hadn't heard about this 9-page document before. I suspect we'll be hearing more about that individual who wrote it.
Interesting. So this is a good transition to the question of political leadership. Merrick Garland was quoted last week by NPR once again saying he was committed to prosecuting all of those responsible for 1-6, irrespective of who they are or what positions they had. And they do seem to be working their way up the chain. Is there any sign that the investigation is yet focusing on political echelon type people?
Well, I really don't see it yet. There are little intriguing things like that. There was another development last week or the week before. An important oath keeper, Joshua James, pled guilty to 2 of the top charges against him, including seditious conspiracy. And he was part of the detail providing security to Roger Stone. But honestly, there is no reference to, in the indictment or in his statement of offense accompanying his guilty plea, that implicate or says anything about Stone. So I really don't see it so far. I just don't see it at the criminal level. Obviously, the select committee recently, the House Select Committee, filed that civil brief in a case involving Professor Eastman, in which it laid out a theory that Eastman had invoked attorney-client privilege to protect his emails, and among many other reasons they said that wasn't applicable was the crime fraud exception, and they laid out a couple crimes they felt that Trump had likely committed.
But that is the committee's view, not
exactly.
A reflection of where the investigation is.
No, exactly.
So for those of you who are wondering about the background noise on when Roger is talking, there is a construction going on in an apartment adjacent to the one that he is living in. And so there is nothing we can do about it. And so let's just, just enjoy the sounds of light carpentry. And, the virtual jungle studio has many guests in this case, including general contractors. Let's talk about the seditious conspiracy plea. This came rather quickly after there was a seditious conspiracy indictment for the first time. You made reference to it a few moments ago. What do you think the significance of this is, and what does it tell us about where the Justice Department is on the Oath Keepers and seditious conspiracy front?
I think it's a very good sign for the Justice Department. They've now got 5 guilty pleas from Oath Keepers involved in this conspiracy, allegedly involved, or I guess involved. And he pled to the top charges: seditious conspiracy and conspiracy to obstruct an official proceeding. So those are both 20-year felony maximums. The guidelines for him, even with the guilty plea, are between 87 months and 108 months. So I'll help you there. That's 7.25 to 9 years. So, and that's getting the benefit of pleading guilty. And he spent a lot of time with Rhodes, Stuart Rhodes, Elmer Stuart Rhodes, the leader of the Oath Keepers, who is the top defendant.
And a Yale Law School graduate.
Yes, right. So he spent time with him beforehand and also afterwards, after these events. And it's an interesting statement of offense. Usually these, when you plead guilty, you provide there's a written statement of offense where you admit to facts that are sufficient to prove the crime alleged. And typically they've been sort of minimalist and provide much less information than the criminal complaint did. This one is very long, and it provides additional information that wasn't in either the indictment or the criminal complaint. And so it's interesting that way. I don't know if that's a reflection of concern about making sure that the seditious conspiracy charge will stick and that the judge would accept the plea, or if it's more a matter of trying to lock him in because they're a little worried that he might, when they call him to the stand, that he might try to wriggle out of it. But in any event, it has a lot of little interesting details, and he spent a lot of time with Rhodes, and including almost a month after the event, where Rhodes had him go to Texas and provide security, gave him a burner phone, told him to develop a new identity, a new driver's license, change his appearance, gave him an AR-15, told him that he didn't want to be taken basically without a fight, and accompanied Rhodes or helped him buy thousands and thousands of dollars of more weaponry in preparation for continuing resistance against the inauguration or, if need be, the Biden administration. There was also one detail I hadn't seen before about before January 6th, where he said that Rhodes had instructed him and others to be prepared to patrol the perimeter of the White House and if asked, and to use lethal force if necessary to keep the National Guard or other governor forces from removing Trump from the White House as a result of the election. So that was a detail I hadn't seen before.
So you mentioned that the plea includes obstructing an official proceeding, which is a good transition to the fact that Judge Carl Nichols has rejected, not this particular plea, but this theory of liability in a different case. A bunch of judges, as we've discussed, a bunch of judges have accepted it, some with more questions than others. This is the first district judge in a January 6th context, or I think in any context, to say, the statute that the government is relying on doesn't reach the conduct that it is alleging. So give us a little background on this. What is the controversy now that there's a dispute among the district judges? And what is the statute? And what is the conduct that the government is trying to use it for?
Yeah, this has become the most important charge, really, felony charge that they've used in the January 6th cases. It's 18 USC 1512 C2. It's called corruptly obstructing an official proceeding. And right now we've got more than 760 people charged in federal court for crimes arising out of January 6th, and more than 280 of them are charged with this offense. I would say probably close to 90% of the felony charges, people charged with felonies are charged with this, among others. It's usually the top charge in terms of potential penalty. Well, it's always the top charge, except in the seditious conspiracy cases. So it's really, really important. Some of the celebrated defendants in these cases have already pled guilty to solely that charge, including Jacob Chansley, who's the one better known as the guy with the horns.
Yeah, the shaman. He's
The
my
shaman.
hero.
And actually, four of the Oath Keepers who have pled guilty pled to not Joshua James, but James did plead to one, but he also pled to seditious conspiracy. The other four pled only to this charge and conspiracy to commit this charge. So all of those would evaporate if an appellate court accepted this opinion, this reasoning.
All of which strikes me as evidence that the government must be super confident of its reading in order to rely this heavily on it. No?
Well, I hope so. There had been, the charge raised eyebrows right from the start. I think what it is they don't want to charge people with insurrection, which is politically explosive and has some different difficult elements to prove. And they were reluctant to go with seditious conspiracy. A lot of these cases aren't conspiracies. So this was their choice. And originally, it did raise some eyebrows because it was enacted in 2002 as part of the Sarbanes-Oxley law, which everyone thinks of as a financial, something triggered certainly by concerns over the ability to prosecute financial crimes. It was passed in the wake of the Enron collapse. So early on, a couple judges, before it had been briefed, Randolph Moss and Amit Mehta made comments from the bench. Gee, I'm a little concerned about this. They were mainly concerned, in fairness, about the intent element corruptly. But then once it had been briefed, the judges all seemed to be reassured. The first to green-light it was Dabney Friedrich, who's a Trump appointee, and then Moss and Mehta. And at this point, 10 judges have all approved of it. 7 of them have written analyses. So it looked really solid. And then we got this ruling from Judge Nichols. Now, he doesn't really focus on the corruptly element. He focuses on the word otherwise, actually, which was a word that some of the other judges had looked at. But he comes up with a very, very narrow interpretation. And it's not crazy. It's plausible. And the way he crafts it could appeal to some people on the Supreme Court. So it's a concern. It's still definitely a minority view. It comes to an incredibly narrow and crabbed reading of a statute that on its face is quite broad.
Yeah, so I want to argue that it is a little bit crazy. So can you read the statute, including C1, which is necessary to understand the context that he's referring to?
Yeah. Yeah. So the statute it does have these two sections. And so Part C begins whoever corruptly, and then one alters, destroys, mutilates, or conceals a record, and I'll do some dots, with intent to impair the object's integrity or availability for use in an official proceeding, or, then two, otherwise obstructs, influences, or impedes any official proceeding. So he focuses on this word otherwise, and he says, well, we need to give it some meaning. So it could mean either that section 1 is sort of a subcategory of section 2, that section 2 is broader, but he says, no, I don't think so, because you don't really need section 1 in that event. And so then he comes up with the theory that section 2 has to be similar crimes to alters, destroys, and mutilates a record. So he says, he says that's all it means then is very similar, like falsifying a record or other ways of acting upon a record to make it unavailable. And that is a far cry from what Section 2 says.
Yeah, I want to suggest that it is not a plausible reading. And having benefited from none of the briefing in any of these cases, here is my alternative reading. There is, prior to Sarbanes-Oxley, this C1, and Congress sees all kinds
No, these are both parts of Sarbanes-Oxley.
Sorry. Okay. So Congress passes C1 to describe physical destruction of property or physical destruction of or alteration of records, and C2 to describe other forms of obstructing proceedings that do not involve physical destruction or alteration of records. In other words, if you obstruct a proceeding by mutilating a document, that is covered by C1. But if you obstruct a proceeding by barging in and corruptly forcing, say, threatening to hang the vice president unless you get what you want, that's not going to be covered by that section. We have a different section for that. And so I think the otherwise means precisely, if Congress had meant to say similarly, it could have used a word like similarly or in some like fashion. It's not talking about some like fashion. It's talking about some different fashion, no?
Yes, that's the way Judge Randolph Moss read it, which I agree is a more sensible way to read it. I think that what Judge Nichols can say in his defense is that there is this Supreme Court case called Begay versus United States, and that's part of what he's relying on, and that involved an interpretation of the word otherwise, and there the majority, and it was a split ruling, and not split on the normal political lines, but 5 judges in that case read the passage after otherwise to be sort of similar to the first 3. But I think what's missing is that the context of that, it was a construction of it's one of these statutes where you'll get a 15-year mandatory sentence if you have unlawful possession of a weapon, and you've been convicted of a previous violent felony or certain other crimes. And the question was, is a DUI a violent felony? And I think 5 justices were thinking, you're going to send a guy to mandatory 15 years for DUI? And so they were grasping at straws a little bit. That's what I think was happening. It's called the Armed Career Criminal Act. And they don't really say that you must always interpret otherwise this way. They say specifically that they aren't saying that. So that's the basis for him interpreting it this way, Judge Nichols. But I mean, I think you're right that most people would not. Most people that aren't on the Supreme Court. Now, I think if this gets to the Supreme Court, I think it's anybody's guess what happens.
So, what's your sense of what the Justice Department does with this? One thing they could do is nothing, and the decision doesn't bind anybody. It's just a district court opinion. They've got 10 on their side, so you could just not appeal it, let this charge fall out of this case, and protect your reading of the statute that way. You could also take the position, hey, we're going to have to litigate this at some point in the DC Circuit because somebody's going to get convicted of this on direct at trial. In fact, I think Mr. Reffitt already did, and he's presumably going to appeal. And so we're going to end up with this in the DC Circuit anyway. We may as well take it up ourselves. What do you think the Justice Department does here?
I think that's right. I mean, I think that's what they should do. And I asked this question of Barbara McQuaid in my story, and she thought they ought to take it up for exactly that reason. It's going to get there. It's crucial. If this is not going to work, if the Supreme Court is not going to let it go, then they need to start charging something else. So I think that's the answer. But this particular defendant, Garrett Miller, does have, I think, 11 other charges, including 5 other felonies. So it's conceivable they could just go forward.
Proceed without him.
Yeah.
But tell me, if they were to take it up and the DC Circuit were to side with the government, would there be a circuit split such that the Supreme Court would feel obliged to hear it, or have other circuits looked at this question, and what side are they on to the extent they have?
The Eighth Circuit has looked at this question, obviously outside the context of a non-capital riot case, and they approved it against the specific argument that Judge Nichols makes. The Ninth Circuit has also approved a 1512c2 case that didn't involve a record, although they didn't comment on this issue. I'm not aware of any circuit that has accepted this. It's 10 district judges that have gone the other way, plus the Eighth Circuit.
Yeah, so that's interesting. So if they prevailed at the DC Circuit, the DC Circuit's opinion would be harmonious with the Eighth Circuit's opinion, and the Supreme Court could actually duck it on that basis.
Right, if they wanted to duck it.
Right. Well, so before we wrap, what are the major events upcoming in 1/6 criminal accountability land over the next few weeks? What are we looking at?
Well, we do have, I mentioned that odd misdemeanor bench trial coming up, but then in April, we have a lot of trials. Of course, a lot of these at the last minute get pushed off, so it's a little hard to predict. And but I think that we might get one where somebody is going to try to make some sort of formal or semi-formal or informal claim that it's Trump's fault, and that's why I'm not guilty. There are formal ways to try to do that. There's something called the public authority defense and something called entrapment by estoppel. That would be the formal way to do it. There might be ways to sneak it into either your opening or your summation, ways to imply it. But I think that at least one of those cases coming up next month, the defendant wants to go that route. Judges have not been very receptive to that so far.
Yeah, the president made me do it defense is going to be a tough one. And
Yeah.
it's going to be a tough one. And even if a judge lets it through, it's going to be a tough one in front of a DC jury. We are going to leave it there. Roger Parloff, thank you so much for joining us today.
Thank you.
The Lawfare podcast is produced in cooperation with the Brookings Institution. Our audio engineer this episode is the great Hamza Shittu of Goat Rodeo. You need to do your part to support the Lawfare podcast. So if you are not already a material supporter of Lawfare, please become one at patreon.com/lawfare. That's patreon.com/lawfare. You can join our Lawfare live events. You can get an ad-free version of this podcast. It's a great thing. Just do it. You know you've been thinking about it. The Lawfare podcast is edited by Jen Patja Howell. Our music is performed by Sophia Yan. And as always, thanks for listening.